Case number 119012 in the matter of Jeffrey A. Mason.
May it please the court, Stan Haslett appearing for the Disciplinary Administrator's Office. Your Honor, I would like to reserve 2 minutes for rebuttal.
Granted.
This is an original proceeding in attorney discipline arising as a result of a hearing that occurred on September 14th of 2017. Respondent appeared in person at that hearing with his counsel, John Ambrosio. The panel report was signed on March 1st of 2018 and docketed with this court on March 6th of 2018. The respondent has not taken exceptions with the findings of fact. In fact, there was a stipulation as to the rule violations and
Excuse me, counsel, let me interrupt you for just a second. The clock? Thank you.
I was holding it for a minute, Judge.
Oh, okay, thank you.
Sorry.
Go ahead. I'm sorry, Mr. Haslett.
That's okay. In fact, the respondent stipulated to the facts and to the rule violations diligence, communication, and conduct involving dishonesty, 8.4c. The respondent has timely filed documents under Supreme Court Rule 211G5 showing that he has complied with his proposed probation plan. The probation plan obviously is not in effect because he's not practicing law right now, but he has an affidavit from Mr. Mason himself, an affidavit from his proposed supervising attorney, Ron Benary, and then there's also a letter from his psychologist that's there. I have no objection to that. I think everything is in order there. It's my understanding from talking to Mr. Ambrosio when we came in here today that there's an additional letter from therapist, which he received late last night, and Mr. Ambrosio gave me kind of a brief summary of what was in that letter, and I have no objection to that being added to the record for your review. The facts of this particular case, the respondent represented the Northwest Kansas Area Medical Foundation. It was a nonprofit corporation formed under Internal Revenue Code 501c3. As part of the representation, the respondent prepared annual corporation reports, which he did, and he was to have filed the IRS 990 forms annually, which he did not do from 2010 through 2016. The 990 form and the proper filing of that form allows the foundation to be exempt from income tax and allows those who contribute to the foundation to deduct those donations from their income tax. That's significant because the foundation every year had a golf tournament in which they wanted people to donate. The fact that the foundation lost its 501c3 status as a result of these 990 forms meant two things: that the foundation could not exempt the money they received from income tax, and it meant that the donors could not deduct their donations from their income tax. On July 5th of 2016, the foundation learned that their 501c3 status had been revoked. Prior to July 5th of 2016, the respondent, by his admission, had talked to various members of the corporation, the foundation, and advised them that the 990 forms had been filed or that he was working on them. As late as January 12th of 2017, he told a board member that he would provide her with the forms and he would call the IRS to check on the status, when in fact he didn't tell them that the forms had not been filed at all. That's somewhat significant because the respondent appeared in front of this court, didn't appear in front of this court, but on December 23rd of 2016, just a couple of weeks before he told the board member that, this court suspended the respondent from the practice of law for 6 months. With respect to the consequences of the misconduct, at the time of the hearing on this case on September of 2017, the foundation had lost its 501c3 status. The golf tournament has not been held. The last year it was held was in 2016 because the foundation does not have the tax-exempt status. Learned this from the complainant in this case, who was an attorney who took over representation of the foundation. At the time of the hearing in September of 2017, it was still undecided as to whether or not the IRS was going to allow the people who had taken deductions from 2010 through 2016 to actually be allowed those deductions. What has happened, and again, the foundation had decided not to have the golf tournament in 2017 and 2018. So, and in 2016, they made $45,000 on that golf tournament. So you can see that the panel decided that there were damages because they didn't have the golf tournament in 2017 of $45,000. Since the hearing, and I've talked to Mr. Ambrosio, and he's talked to his client, and they don't have a problem with me telling you what's happened since the hearing in September of 2017. The 501c3 status is still revoked. That status cannot be reinstated until the IRS makes a decision about whether or not these deductions are going to be allowed by the folks who donated from 2010 through 2016. The complainant in the case, the attorney who took over the representation of the foundation, said that he is confident that those deductions are going to be reinstated, but that will not happen until after the beginning of the year. But again, for the year 2018, there was no golf tournament. So arguably, there's another loss of approximately $45,000 to the foundation. If you read the respondent's affidavit in connection with this latest filing with the court about his proposed probation plan, you will see that he is in fact covered by malpractice insurance. He has reported this potential claim to his malpractice carrier, and he has pledged in that affidavit, as I understand it, to make the foundation whole whenever it's determined how much money they actually lost. The issue of appropriate discipline. This recommendation is made much more difficult by what I'm about to explain. As I stated earlier, on December 23rd of 2016, this court suspended the respondent's license to practice law. That was as a result of numerous rule violations, including dishonesty and 2 separate complaints that were filed with our office. The suspension was to last for a period of 6 months, at which time the respondent could apply for reinstatement. And then he would have a 3-year supervised probation. But at the panel hearing in the present disciplinary case, which occurred back in September of 2017, the respondent admitted that he knew about the foundation misconduct at the time of the panel hearing in the previous case, and at the time he appeared before this court when he appeared before the court in October of 2016. And that's the problem, because we wouldn't be here today had he told us about the fact that this additional misconduct occurred, which obviously involved additional misconduct or additional dishonest conduct. At the panel hearing in September of 2017, the respondent stated the following: "How in the world could I have sat here and in front of the Supreme Court and said there were no other problem cases out there with this thing," he's talking about the foundation thing, "with this thing there, because it was there." At the hearing, he explained, at this hearing, he explained that it is a result of anxiety and depression. And you know what, I don't really have any doubt that that's true. The recommendation in this particular case, from the respondent's perspective, was that he receive a censure from this court and that he be placed on probation, or in the alternative, that he be suspended for a period of time, that this court suspend the imposition of the sentence and place the respondent on probation. It should be noted that the respondent did not seek to be reinstated when he could have, which would have been about June of 2017. Our recommendation was indefinite suspension made retroactive to when this court suspended the respondent in the first place, which was December 23rd of 2016. That was the date of the original suspension by this court, which would make him eligible for reinstatement, to apply for reinstatement in December of 2019. A reinstatement hearing obviously would be required at that time if that recommendation were to be followed. Given the way this played out, I mean, the fact that he didn't acknowledge that this misconduct was out there at the time of his first disciplinary hearing, at the time he appeared before this court. Obviously, we had another disciplinary hearing. Obviously, we're here today. I mean, it could have all been wrapped up at one time. So the ramifications obviously are pretty serious, not to mention the fact that he had the knowledge and he just couldn't, he didn't tell us, he didn't self-report. That being said, I mean, I think the recommendation for discipline that we're making today could have been much more serious, or not much more serious, but more serious. It could have been a recommendation for disbarment given the additional dishonesty that occurred. But I want to tell you why I am not recommending that. Because I think...
You're actually going 2 steps back, because you're going to an indefinite suspension and you want to make it retroactive.
Right.
Correct.
Okay, so just so, I want to understand both steps.
Right.
Right. Reason I'm not recommending the ultimate sanction, which is disbarment, is that there is a lot of evidence of mitigation in this case. I mean, this is an individual who's been active in the bar. This is an individual who was on the Judicial Qualifications Commission. I've known him for quite some time. I think everybody was startled, shocked, with the adjectives I would use when they found out about this misconduct. He has great support. He has his family here, his longtime partner, Ron Benary. He has KLAP, he has Cal Williams, who is his proposed KLAP monitor. He has Ms. Morose here. They're all working for him. Now, if you look at the record, I'm impressed by the fact that his psychologist is in Denver. Since 2015, he's made, as I read this correctly, 105 trips to Denver for 105 separate 2-hour sessions with the psychologist. So, I mean, he's working to try to get rid of this problem. The panel recommended indefinite suspension retroactive to the date of suspension of December 23rd of 2016. They recognized that meant a reinstatement hearing, and they felt like the respondent at that point in time should present some sort of plan of probation, at that supervised probation for a 3-year period of time.
At the reinstatement hearing, at the time of a reinstatement hearing.
Correct.
Okay.
So, I mean, he wouldn't be eligible under their recommendation or our recommendation to apply for reinstatement until December 23rd of 2019.
Yeah.
And in both instances, he'd have to go through a reinstatement hearing. Panel did recommend 3 years supervised probation after that. I did not make that recommendation, but if you have a 219 hearing, I think at that point in time I could figure out whether I thought supervised probation for the additional time was appropriate. The panel said in making its recommendation that at this time the hearing panel does not have confidence that there are no other issues or that the respondent will not repeat the misconduct. Given the way this all played out, given the fact that he had the opportunity to tell us, I mean, I understand why they came to that conclusion, and I agree with it, which is the reason I'm making the recommendation that I am. That being said, if you disagree with the recommendation of the panel or you disagree with the recommendation I'm making to you, I have no qualms whatsoever about the supervising attorney, Mr. Benary. I have no qualms at all with the proposed monitor from KLAP, Mr. Williams. I think if and when the respondent is placed on probation, supervised probation, they will do an excellent job.
You mentioned that Mr. Mason's attempting to make restitution, and that's by attempting or filing through his insurance carrier a claim. He self-reported. Have there been any other attempts besides that to make restitution? No.
He's notified his carrier, as far as I know. I guess he's notified his carrier. I don't think he's heard anything more about that. I think that there will be eventually, if there has not already been made, a claim made by the foundation.
The foundation hasn't made a claim. Okay.
I don't believe they have.
Okay.
But.
Anything else? Thank you, Mr. Hassel.
Okay, thank you.
May it please the court, John Ambrosio on behalf of the respondent. The facts as indicated in the panel report and as stated by Mr. Haslett are absolutely correct, and the rules violations are listed and they are correct. This is maybe one of the hardest cases that I've had since I've been coming up here doing disciplinary cases. The question you have to look at is, what is the punishment? What is the discipline to be meted out? And obviously we asked down below for him to be placed on probation to allow him to practice law because, number one, he has more support than very few lawyers have as much support as he has. He has worked his program. He has gone to therapy. He is on medication. The question you are probably all asking yourself is, why, under all that's holy, did he not just simply tell the panel, Mr. Haslett's office, his own lawyer, about this other thing that is out there at the time he had that first panel hearing? And the answer, as I understand from talking to Dr. Higginbottom, and as she testified at this hearing and the one before, is because of his depression, because of his anxiety, because of his narcissism, which are all of his problems, he was unable to come forward and admit it and say that. Why, you also say, would he also be less than honest with his clients when they found out about it? Why did he tell them he was working on it? Because of the affliction that I have listed and because of what Dr. Higginbottom stated in her testimony. Here's one of the most interesting things in this case. Dr. Higginbottom, at the first hearing and before we came to the Supreme Court, stated to that panel, Mr. Mason is not ready to practice law at this time. He should be suspended for a period of time, and she agreed that he should be suspended for 6 months. That's what she said way back when, before you issued your decision December 23rd of 2016. If you read the materials that I filed with the court last week, and also included in the materials that I had to file secondarily, she indicates that now he has done everything that is needed to become a meaningful member of the bar of the state of Kansas. He has done everything that he can to help himself. And I think that's important because this is not a therapist who back then was protecting him. She said he needed to lose his license for a while. He needed to be punished. He needed something to happen, and that's not what she's saying now. He is, I don't know if you ever beat depression, and I don't understand depression since I never had it, but he is working his program and he has a lot of support. What his probation supervisor is doing, even though he's unable to practice law, and this is important, they're making sure that there's nothing else out there. Every week they pull at random a series of cases that are down in the bowels of their building, old cases, and they take all of those cases out, and Mr. Veneri, with my client, goes through those to make sure there are no other problems. We're trying to assure that no other client is going to be hurt. We're trying to assure that because of his depression, his anxiety, and his narcissism, that there are not more problems. My client would like to address you, and he's going to be a little longer than normally my clients are, because it's important, because this is part of his treatment to come here today. This is part of what he needs to do to rehabilitate himself. We are asking that he be placed on probation, that he be allowed to practice law, that Mr. Veneri supervise his practice, that he continue to go to therapy, that he continue to take his antidepressant drugs, that he continue to do work with KLAP, that he continue to work with Cal Williams, which he's been doing even though he's suspended. And even though he could have come back 6 months after you suspended him, because of this and because he knew he wasn't ready, he chose not to come back. I'm sorry.
Wasn't there a reinstatement hearing ordered on that 6 months?
No.
No, I don't think so.
took
I don't think so.
I thought that's what Mr. Haslett said earlier.
It was.
Okay.
I heard him say that too, but I just
Okay.
looked. I got it in front of me here. Let me ask you this:
So,
the panel heard the evidence and still made the conclusion in paragraph 28A that he's not ready yet in the interest of the state of Kansas and the citizens of the state of Kansas.
correct.
So we've got that to deal with. You've took no exception to it, other than you've now filed some therapist letters and stuff that say, oh, really, he's okay, and this probation plan will protect the citizens of the state of Kansas. I don't know how to reconcile the panel's factual findings, which you've taken no exception to, and going forward with what you've recommended, because they seem to be contrary to the findings of the panel. I mean, you're kind of making today your reinstatement hearing, and that requires a factual development of a record that you're kind of developing on the fly, and I just don't see how I can do what you want us to do. So help me with that.
I appreciate what the panel said, and when I did not take exception, but I do always put that little thing in where I say I am going to argue in mitigation of punishment. So I always leave that open, even when I don't take exceptions.
And I understand that part, but we've got a finding about the interest of the citizens of the state of Kansas, and these proceedings really are pretty much about protecting the citizens of the state of
Without
Kansas.
question. Without question. Without question. And I've agonized over this, and I knew that would be a question, and I have very little answer to that other than to say this was part of his affliction. And I understand what the panel said, and the panel didn't buy into what Dr. Higginbottom said, although they did the first time, and the panel didn't think he was ready. And I appreciate that. And I disagree with them because everything in the papers that I have prepared and sent and filed with the court tell me that he's ready. Tell me that he has a new lease on life. Tell me that the public will be protected.
If you disagree with the fact finding, shouldn't you procedurally take exception to it?
Normally, I don't do that. Normally,
Well,
what I
but,
do...
but
no, I don't.
procedurally, our rules say it's deemed admitted, and yet you're here arguing I disagree with it. So I'm trying to, I guess I'm with my colleague. How do we thread the needle you're asking us to
Well,
thread?
I don't always take exceptions. What I always say, and I always cover it by that little thing that I put in there that says, but I'm going to argue mitigation of punishment. I hear what the panel said. I don't have to agree with the panel. I don't have to take exceptions to
But
disagree.
we do, under our rules. If there's no exception taken, the panel's findings of fact are deemed admitted. And so whether you agree with it or not, we're stuck with it.
And I think, counsel, for this point, this is not arguing about whether he gets 6 months or 4 months or probate, you know. I think if you want to fight about this, what you needed to do was say substantial competent evidence didn't support this finding of the panel, because I got this great therapist over here and look at all the great evidence that she had, so you can't make this conclusion under the burden of proof that we're at. And so that's why I'm saying we're handcuffed here.
I don't think the Supreme Court on disciplinary cases is handicapped at all, ever. I think you can do whatever you want, when you want to do in these disciplinary cases. So I'm sorry, Justice Biles, I don't buy that, and I don't buy what the other justice said. However, not to be bellicose or bombastic, to get back to my simple argument, you can do what you want, okay? I don't have to take exceptions all the time. Maybe it's because I hate writing briefs and I hate doing that type of the work. But when we're just going to argue against the punishment that the panel suggested, I think that's all that's necessary. And you're right, I do have this wonderful therapist, and I do have this wonderful report. And I think that's all that you need to hang your hat and give this man a chance. I guess that wasn't too bellicose, but... And I hope that answers your question. But I can tell from your expression that it does not.
Well, you're telling me to ignore a Supreme Court rule. And you're saying, yeah, the Supreme Court can ignore its own rules. So that really looks good, doesn't it?
Let me take another tack here. What if we decline to accept your late filed documents?
Well, it wasn't late
Because-
filed.
Well, your documents that were presented, if we decline to accept that as facts because you had your factual hearing before the panel.
Then
What
why do you
the-
have the rule that says that I'm supposed to file the affidavit of the probation person?
No, I'm talking about the factual statements from the therapist that you're arguing are facts that should influence our disposition.
And your question is,
My question is, on what basis do we accept new facts that contradict the hearing panel finding of facts?
Your Honor, I don't think they're new facts. I think they're just a follow-up on what occurred at the panel hearing. And that's not forbidden by the rules, as I understand it. With the permission of the court, my client would like to address the court.
May it please the court. My name's Jeff Mason, and I am a suspended lawyer. That's hard to say, but I am a suspended lawyer. I've been suspended since December 23rd of 2016. I was eligible to come back, as has been stated, in June of 2017, and because of the complaint that's currently being heard by this court, I chose not to do that because I didn't feel like it was appropriate. I didn't feel like I was ready. There were 2 more complaints filed, actually, after the hearing and determination by this court. I've been told that I'm going to receive an informal admonition on one of those complaints. I've not received that as of yet, but that's what I've been told. The other one is this one, the Goodland Medical Foundation. And as was stated, I have been involved with the Goodland Medical Foundation for 28 years. It's a long time to be involved with that organization, but I support and continue to support its mission. And I was not the heavy lifter in that organization. I was a person who helped keep things organized, but there were others who did much more work and deserve much more credit for what the Goodland Medical Foundation did than me, period. I did not report it. I have reported it to my carrier. The Medical Foundation has not made a complaint or a claim to my carrier as of this date that I am aware of, but I have reported it. So why didn't I report this one? I've learned a lot since October of 2015 about myself through my therapy. I've learned that I'm narcissistic, not clinically narcissistic, but narcissistic, which means I have a concern for myself more than I do others, including clients. I have a need to please, which means I could not admit that I made a mistake. I could not admit that I failed. That leads to a lot of anxiety. What, as I'm working for the Medical Foundation, I'm thinking as I'm looking at those 990s, what if I don't do it right? What if I make a mistake? What if I don't check a box right? What if they come back and say, you don't get this? What if, what if, what if? And I realize that's not, it sounds like an excuse, but that's how it works with anxiety. It paralyzes you. Dr. Higginbotham in her previous reports has said that that's what occurred. But I'm also a fixer. Well, I was always going to fix this. But I wasn't. I didn't. I was a failure, and I could not admit that. And in fact, I lied about it. That is also very difficult for me to say. But I did. I lied about it. I rationalized that because I was going to fix it, that I didn't need to tell anybody, that I was going to take care of it. I avoided it, and avoidance became a normalized behavior. The same type of avoidance and behavior that took place in the prior 2 complaints for which I've been disciplined. I didn't want to look bad, and I didn't want to be a failure. One of the things that I have read is a book called Leadership and Self-Deception by the Arbinger Institute. And it talks about self-deception, how through a process in your brain, you can self-deceive yourself into thinking that you're doing the right thing. It's not right, and it points out how that is not right and how to change that thinking. That is what I've been working on for 2.5 years. You need to know that there are 2 other complaints that are still in the system. The one I mentioned that is supposed to be an informal admonition, and another one that I self-reported involving a conflict of interest that we're waiting for a decision from the court on that case to see whether it's an issue. And the disciplinary administrator has given me a letter that says, back when I filed the self-report, saying we're not going to worry about this one until it's through the judicial process. I don't want to hide that from you. I want you to know that. There's also a third possibility out there. A gentleman by the name of Lincoln Wilson, who was charged with election misconduct by Mr. Kobach's office that I represented for a period of time. And I represented him in a mortgage foreclosure case, and I represented him in some landlord-tenant actions. Has made noises to others. He's never talked to me, but has made noises to others that he's thinking about filing a complaint. That was over a year ago that he said that. I've heard nothing. I don't know, but I don't want to, I didn't admit to anything the last time I was here, and I want you to know I can't control those things, but they're out there. I don't know what the results will be from the investigations. I believe they are not going to be fruitful and that there shouldn't be any further discipline, but I didn't want this court to say, okay, why didn't you tell us about this one too? I'm telling you they're there. The recommendation of the court is indefinite, or of the panel and of Mr. Hazlitt, is indefinite suspension, and I believe there's 3 reasons why that should not happen. The first is, I want to practice law. Now, does that make a difference? I think it does. If I didn't want to practice law, I wouldn't be here. I have enjoyed immensely the exchanges that took place in the prior 3 cases today. I enjoyed that process of working with colleagues. But that's also a source of anxiety. The seminar that I went to by KLAP back in April, one of the people said, you know, the difference between the stresses that physicians have and the stresses that lawyers have is the physician walks into the operating room to do a job with his team, and he doesn't have another team walking in the other door trying to kill the patient while he's trying to save it. That's the environment we operate in. That creates a lot of anxiety. That's one of the reasons I want to limit my practice to what I'm going to do, so that I'm not involved in high conflict divorces. I'm not involved in litigation, heavy litigation that involves heavy discovery. Those are the things that cause me problems. I've learned that. I recognize that. I want to finish the job. I was sworn in 35 years ago next week, September 18th, 1983. I want to finish the job. I also think it's important that others know that when you go through what I've gone through, that you can come back. That there are resources available out there to help you when you have the issues that I have. 28, according to the ABA study that from last year, 28% of lawyers suffer from clinical depression. 19% suffer from clinical anxiety. 23% suffer from clinical stress. That's beyond the normal stress. But the profession is now finally recognizing that issue. Through the ABA efforts, there's numerous podcasts out there that I listen to by experts in lawyer well-being, lawyer wellness. There was a retreat this summer put on by one of the software vendors, Rocket Matter. It's a practice management software that they put on to help lawyers understand how the profession can hurt them and how they can deal with it. I wasn't able to attend, but the profession is starting to recognize these issues and understand that it's important for lawyers to understand them too, and to know where the resources are to get help. The second reason is the least important, but I think it needs to be brought up, and that is the need for lawyers. The 9-county Northwest Kansas area has a population of 31,500 people, and we have 21 to 25 full-time lawyers. By comparison, Lyon County has a population of about 33,000. They have 40. Montgomery County has a population of about 32,000. They have 39. McPherson County has a population of about 28,000. They have 40. We are an underserved area. Access to justice is important. That gives me to my last reason, the purpose of discipline, the appropriate punishment. I have suffered from the suspension that was issued in December of 2016. The economic impact is there. There's also been a significant family impact. I had a partner who was my son-in-law, married to my daughter, and he chose, after this last complaint came out, to leave, move to Hayes with my daughter and my 2 grandchildren. That hurts. My wife and I have had extensive discussions. She considered divorce. That hurts. There's also a community reaction. I was the front page news on January, second week of January, for my suspension in Goodland, on the Goodland Daily News. Front right corner, where everybody looks, right there. There's one grocery store in Goodland, Walmart. It's also where you get your jeans, your underwear, your pharmacy, everything. One place. There's one school system with all the activities that go with it. I cannot run away in Goodland, Kansas, from the fact that I'm suspended. My wife cannot run away from the fact that I'm suspended, because it's always right there in our face. Could have run. I could have left town, but I didn't. We've chosen to stay in Goodland, Kansas, because we think that's the place we need to be. But every week, I'm asked by former clients and friends, are you reinstated yet? I cannot run from it. 2 others in Goodland who received discipline ran. They left. We stayed because I'm willing to face the music. I felt I needed to show that I had learned that I had learned what I needed to do, and I had done what I needed to do to make myself a better person and a better lawyer. That there's hope even when you make the mistakes that I did. The other purpose of discipline, I think, is rehabilitation. Carl Menninger. Prevent further harm to clients and the public. The ABA standards for imposing sanctions were last amended in 1992. They talk about the deterrent effect of discipline. Those guidelines were developed long before we began talking about lawyer wellness, about depression, anxiety in the profession. I have a probation plan. The ABA, in their report from the 2016 study that was approved by the ABA in 2017, says probation programs promote wellness. A person can continue practicing under supervision and specified conditions that include training, testing, monitoring, and treatment. This places the lawyer facing a mental health or substance use crisis on the path to better client service and a lifetime of greater well-being. I believe that's true after what I've been through. You have in the record Mr. Veneri's affidavit. We meet every day. We meet on Saturdays. We review files. We review his files. We review what I'm doing for him, what paperwork I'm preparing, research that I'm doing for him, that I provide to him, and he then provides to clients. I have no client contact. I do not do anything that would indicate that I'm having any client contact or that I'm trying to represent anybody, ever. I've not done that since December 23rd, 2016. I do have an abstract company, and we also review those files. Mr. Veneri is not involved in the abstract company, but we review those things to make sure I'm staying on task and doing the things that I need to do. I participate in the resiliency group that's headed by Dr. Ray Sedgwick. And that is one of the filings, I believe, Justice Johnson, that you're referring to. But she says that I was recalcitrant. I was reluctant. But that has changed over the 3 years that I've been involved in that program. That's through KLAB. I struggled with depression. With medication management and psychotherapy, that has been lifted to a substantial degree. His story is an exemplary one of man's fall from grace and his efforts to rise above his failures and shortcomings to be a man of responsibility, compassion, and dedication to the law. She's seen that. I didn't tell her to say that. That's what she's seen in me. Dr. Gunderson, in her letter, based on the work he has done and the insights he has gained, it is highly unlikely the same problems he has encountered professionally will recur in the future. It is my professional opinion, stated with reasonable medical certainty, that Mr. Mason is able to practice law with reasonable skill and safety from a medical psychiatric standpoint. I realize those letters are recent. I realize those letters are after the hearing, but the hearing was 7 months ago. I've still been going to Denver. I've still been participating in therapy. I've still been participating in all these activities that I have been told and recommended to do, and I've followed those recommendations. Did I have to? As a suspended lawyer, probably not. But I want to practice law. And so I'm trying to make myself better, and I'm following those recommendations. Dr. Higginbotham, in her report, I don't know what else he could do. The exact wording, I do not know more of what he could do to demonstrate that he has achieved the needed growth required to return to his profession. I have a team. Now, one thing you need to know about Mr. Venneri is that he played football for the mighty Pittsburgh State Gorillas, winningest college football team in NCAA Division II history. If I forgot to tell you that, I'd be in trouble as soon as I walked out of this room. But he tells stories about football. And one of the things that I realize is that football is a team sport. I was a cross-country runner. I was a golfer. I was a track person. Those are individual sports. Those are not truly team sports. I now have a team. I realize I have a team. I had a team before, but I didn't know it and I didn't use it. I have my family, especially my wife. I have Mr. Venneri. I have Cal Williams. I have Ashley and Scarlett, my two rather irreverent assistants. I have my church. I have the resiliency group, Dr. Gunderson, Dr. Higginbotham. And I stand before you, the proverbial 36-point underdog. The report's against me. The disciplinary administrator's recommendation is against me. Apparently procedure may be against me. So why didn't I just pack it up and not even show up? Because I believe in this system. I believe in justice. I believe that attorneys do the right thing for their clients. I have learned that that's what I need to do, and I've learned to address my issues. I don't want to quit. I'm not going to quit. I respectfully request this court grant me the opportunity for probation. And I want to apologize that you're even here. Thank you.
Any
I
questions?
have a couple of questions on the things that you mentioned.
Yes, sir.
I get from what you said that the mortgage fraud client is something that you knew about during the hearing or before the hearing panel. Was the conflict of interest question, had it arisen by the time of the hearing panel?
Yes, and I don't know
Was the
why I
hearing
would have.
panel told about either one of those to
I don't
that factor in?
they were told about the Lincoln Wilson thing. I don't recall whether they were told about the issue with the conflict of interest or, but I do know that they were told about the one involved, yes, the conflict of interest they were told about, but that it was still pending. And then, yes, they were told about the one with informal admonition. Yes, sir.
But those weren't complaints.
I understand that. I just
Okay.
want to know whether stuff that we're being told
I
was
understand.
something the
Apparently
panel
it
was
doesn't
told.
need me, but I wanted to inject that.
I had one question if you were, the other end was finished. I think I heard you mention in the course of Mr. Veneri's supervision that you prepared documents, and then I read Mr. Veneri's affidavit, and he talks about document preparation. Can you just explain a little more
Yes,
detailed what documents you're preparing? and
We will
what you're
review
doing?
files, and I prepare drafts of documents. I prepared drafts of deeds. I prepared drafts of powers of attorney. I prepared drafts of trusts.
Is that for Mr. Veneri's practice or for your title company?
No, that's for Mr. Veneri's practice.
Okay.
And he reviews those and makes whatever changes he feels are appropriate. He is the one that sends those out to clients.
Thank you.
Anything else? Thank you, counsel.
Thank you. Appreciate the court's time.
We'll take this matter under advisement. At this time, court is adjourned. Oh, I'm so sorry.
That's all
I'm
right.
obviously new at this.
I really don't have anything else to offer, but it occurred to me because of the line of questioning, the procedures, procedural issues, that you may have some questions of me.
I do have one about something you said in your introductory remarks that, or maybe it was actually later on, but when you said that you had confidence in the probation plan and the KLAP supervision and that kind of thing. Does your level of confidence in that negate what's appear in your mind, the panel's concern about public interest finding? That's, I can kind of consider that a credibility finding in paragraph 28A. I mean, they heard the evidence and they still came to this conclusion, so they had to believe one over the other. And they had the probation plan in front of them, they had the therapist in front of them, they had the KLAP supervision in front of them. So I'm just trying to figure out how to, from your perspective, how do you balance that out?
I don't feel comfortable with it right now. I think in the future, if we go through a reinstatement hearing, evidence can be presented then that will convince me one way or another what recommendation to make. But if you look at the record, you'll see that the respondent's psychologist said, I don't feel comfortable with him doing anything right now. I wouldn't recommend that he be reinstated right now until this court has a chance to review all of this and see whether they think it's okay for him to be reinstated. I agreed with what the hearing panel decided, and that is, given the misconduct, given the fact that he didn't let us know, didn't let the panel know, didn't let this court know, that justified the extended suspension.
And do you agree that the two little minor items that were mentioned, the conflict of interest question and the Lincoln Wilson deal, that came up during the hearing?
Yes, I do agree. That's my recollection.
I had, my notes were different. I had that the informal admonition was revealed to the panel, the one
Yes.
on which you're expecting informal admonition, and then the conflict. I had those as two separate matters.
They are.
But the Lincoln Wilson matter did not come up with the panel. That's the one where there's just been rumblings in the community. Is that right?
I think it did, but I don't think any complaints ever been filed by that individual.
No, that's my understanding. It's
But
just-
I think it was divulged to the panel.
Okay, so you think all three were mentioned to the panel?
Correct.
Thank you.
And that the informal admonition, I think I need to explain a little bit about that. There was actually, it was a 2-count formal complaint. This case is before you right now. We were going to present evidence on another case where some allegations were made involving competence and I can't
Water
remember what
rights, wasn't it? Water
Yeah.
rights?
Yes, it was a water rights case. I resubmitted that to the review committee, who determined that informal admonition was an appropriate discipline in that case, so that one of the 2 counts goes by the wayside of informal admonition.
Thank you.
Justice Biles, could you tell me which paragraph it was that you're.
28A, which is when they're discussion of mitigation and aggravating circumstances.
$28A. No wonder I couldn't find it. It's cut off on my.
It's on page 8, the bottom of page 8. Maybe that's, it's on the next page, I'm sorry, page 7.
Page 7.
Yeah, and it's actually, well, it's in here.
Is it the personal or emotional problems? If such misfortunes have contributed to violation of the Kansas Rules of Professional Conduct?
Oh, it's on page, I'm completely 33, page 12, paragraph 33. There at the bottom, additionally, placing the respondent on probation is not in the best interest of the legal profession and the citizens of the state of Kansas.
Okay,
That's where I come up with
I
that.
am with you now. I want to tell you that I've always kind of made a distinction when I look at Supreme Court Rule 212 and it talks about admitting or denying the findings of fact, because I feel like the findings of fact are designated that in this hearing report and are the findings of fact of the underlying misconduct. And then it talks about our office and the respondent being able to make a recommendation, which is, I mean, this part that you're talking about is in the section designated as a recommendation. And I've always felt like if the respondent admitted the findings of fact, but in the rule it says that they can still come here and talk to you about whatever the appropriate discipline is, that it was okay to do that. I consider this 33 in the nature of a part of the panel's recommendation.
Yeah, I mean, there may be there may be some legitimate reasons to not look at that, but I don't see how you come up with that conclusion without having made a credibility determination about the evidence that you heard.
Okay.
That's where I was coming from.
Right.
And
You're just trying-
and that would have
I just
been a
wonder-
flag for me.
Excuse me, you're just trying to address the procedural concern
Right.
about taking exceptions.
Correct. My
Okay.
understanding of it.
Anything further from the Thank you, Mr. Haslett.
All right, thank you.